Here we go. Good afternoon, everyone. Today is February 17th, 2022. This is Rajiv as Khanna from immigration.com, the law offices of Rajiv as Khanna PC. This is our 2-weekly phone call every other Thursday, which we hold for the community and try to answer your questions to the best of our ability. And when you logged into the conference, you have heard a series of disclaimers. So please make sure that you are bound by those disclaimers. Let me just make sure you can hear me okay.
The conference is now in conversation mode.
Can you hear me all right, folks? Can you hear me okay?
Yes.
Okay, thank you.
The conference is now in presentation mode.
I will go over the questions I have marked as frequently asked questions first. And here is one that has become quite problematic in recent months. Typical situation is somebody is visiting the United States on a tourist status, B1, B2, or B1 or B2. So any kind of these combination visas, B1/B2, B1 or B2. They apply for an extension. Now, when they apply for an extension, the extension typically stays pending for many months. Now come two scenarios typically. One, their extension is denied. And two, they leave before the extension request is dealt with. Now, technically, there is a section of law called INA 222G, Immigration and Nationality Act, Section 222G. G as in girl. What that section says is, if somebody stays in the United States over and above the time permitted by their I-94 which they got upon entry, their overstay results in an automatic cancellation of their visa stamp. However, there is an exception within the standard operating procedures of the State Department which says if you leave before your extension is denied, you are not subject to the 222G visa revocation. However, what the government has started doing, in fact, we are dealing with a case like that right now. Government has started applying the cancellation of visa even to those cases where the applicants left before their case was denied. Government should not cancel those visas. The posted question presents a similar scenario in a little different twist. Here what happened was, when they came this time after having left the last time, they were told we are only going to give you 3 months stay because your visa has been denied since you overstayed your status the last time, even though they had applied for a B1, B2 extension. So the question is, what should they do? They've only been given 3 months to stay. And my advice would be, if you want to challenge this, because I believe it's a misapplication of the law, and because the 3 agencies involved are themselves misapplying the law and applying it in slightly different ways, which can cause a major problem for the people who are subject to those laws, it may be a good idea to bring this up to your congressman's office. The case in which our client's visa has been denied, we are fighting it at the consular level, and I believe the consulate should give us a letter that says, or a response that says the visa is intact. It has not been cancelled, because our clients in the pending case left the United States before their extension request was decided. So I think you should bring this up to your congressman's office, explain to them, maybe even tell them what you heard from me, that this is an inappropriate application of 222G within the Department of State Standard Operating Procedures. That's called FAM, Foreign Affairs Manual. Foreign Affairs Manual clearly says if you leave while the application is pending, you are not subject to 222G. Bring it up to your congressman's office. Press *5 if you have a follow-up question on this. No new questions. A follow-up question on this discussion. Press *5 on your phone. Okay, there are no questions. Let's go on to the next one. Now there's a bunch of frequently asked questions on interfiling. So what exactly is interfiling? You have an EB2 approval and you decided you wanted to downgrade it to EB3. You filed an I-140 for that and you applied with an I-485 with that because the dates for EB3 were moving faster and they were current. Now when you want to excuse me, move your I-485 basis, or in other words the application, back to your EB2 case, you do something called interfiling. Now all these questions relate to interfiling. The question number 2 is job change after I-140 approval, priority date is current and issues with H-1B transfer and H-1B extensions. Srikumar says, I am on H-1B visa with employer A, approved I-140 with priority date 2015 under EB2. Suggestions on switching employer when priority date is nearing anytime soon. If I switch to employer B, what if my priority date becomes current before employer B's I-140 is approved? So they've got, first of all, there might be a basic misunderstanding here. Oh, I see. You are filing a new perm. So that's very important. If you change employers and you want to transfer the basis back to EB2, you will have to file a new EB2 based perm application. Wait for the I-140 approval. So the question is, what if my priority date becomes current before employer B's I-140 is approved? Well, that depends. Since you have not yet filed 485, if your priority date becomes current, you can go back to the old employer if you so wish. What you should not do is to try to file an I-485 with an old employer whom you have already left with no intention to return back. So that would, I think, be a bad idea. And if you listen to the rest of the frequently asked questions on these issues and read my blog as well as on immigration.com, you should see comments and entries about these sorts of situations. So if you have changed employers, priority date with the old employer becomes current, you could go back and join them if you have a good explanation why you left them in the first place. *5. If you have a follow-up question on this, press *5. No new questions, only follow-up questions. And so first one is from 718. I think that's Illinois. 718, where are you calling from?
So I'm calling from Virginia.
Okay.
So
Go ahead.
my follow-up question for this is, say for example, my EB2, EB3, both I-140 is approved in the same company, and I joined a new company with on EAD. So can I interfile now with EB2 correct?
You cannot, because your approvals are left with the old company. What you have done is you have used
including 485.
Yeah, you have used AC21 to join the new company. That's a different procedure. In AC21, you move your entire green card over because your I-140 is approved and 485 has been pending 180 days. That's what you have done. Okay. So that means your entire green card has been moved over to a new employer. In which category? In whichever category the 485 was filed. In this case, that's EB3. So now you have only EB3. You want to convert to EB2? Go back to the same employer if you have enough reason to do so. Look at the law, talk to your lawyers, or file a new perm-based application with the new employer. And when the time comes up at the I-140 stage, you should probably file a new 485 at that point of time. Go ahead with your question.
Thank you.
You're welcome. Good luck. Area code 469. Where are you calling from? 469?
Yeah. I'm calling from Indiana.
Okay, go ahead.
I'm Sri Kumar, who posted the question about changing employers
Yes, sir.
while the priority date is going to become current. My question is, if I don't have the intention of going back to my old employer, and my priority date becomes current while I am with the new employer, and the new employer, say, for example, has started the perm, but the new I-140 is not yet approved. Okay. How long can I wait? Like my priority date is current, but the new employer is still doing the GC process. So how long do I have?
There is no time limit.
I-485.
Yeah, there is no time limit. There is no time limit. So you can wait as long as you have to. Okay.
Oh, so once my priority date becomes current, I can file I-485 even after 1, 2, 3 years.
As long as the date is current when you file, there is no limit. Once an I-140 is approved, under most circumstances, it is good forever.
Okay, so say the new employer's I-140 is not yet approved.
That's fine.
They are just starting.
That's no problem.
Process.
So that's the same principle. So the I-140, once it gets approved, your priority date became current 6 months ago. 6 months later, your I-140 gets approved. The priority date is now current for many other later cases also. But that means your priority date is still current. You can use that I-140 and file now. There's no need for you to file right when the date becomes current.
Okay, so there is no time limit within which I should file my I-485. I can do it after 1 year, 2 years, or 3 years.
Or 10 years or 20 years.
Okay. Yeah,
okay.
Yeah.
Good luck.
Sounds good. Sounds good. And the other one is like H1B transfer. When I do, I will automatically still get that 3 years.
No, you won't get 3 years if your priority dates are current. You will get 1 year if you are able to explain why you have not filed 485. Then I think you have a good explanation.
Okay.
All right. Good luck, sir.
Sounds good. Thank you.
All right. Bye-bye.
Yeah.
Okay. So again, another frequently asked question on interfiling. Filed at previous employer, 180 days of 485 pending crossed. Concurrent EB3 I-140 downgrade approved. Right. So original EB2 I-140 approved for more than 180 days from the approved date. Received EAD combo card. Moved to new employer on H1 using AC21. Filed 485J. Can I interfile from EB3 to EB2 at the new employer? I just answered that question. And they want me to update it in the frequently asked questions. That will be done this as soon as we finish this recording. So you can share it with people. Do not confuse AC21 with interfiling. So AC21, your EB3 I-140 is approved. Your 485 is attached to that EB3 filing. And 180 days are gone. That's when you become eligible to move your EB3 green card over. You can't move your EB2 green card over because your 485 is not attached to that EB2. And in my blog, you'll see I have the most recent entry clearly says, if you interfile your EB3 I-485 to your EB2 petition, the 180 days countdown begins again on the date of the interfiling request. Okay. So do not confuse AC21 with interfiling. All right. I hope that explains everything to you. *5 if you have a follow-up question on this. Press *5. Okay. This one is from area code 718, Massachusetts. Yes, 718. Go ahead, please.
Hello, sir. The question is, now I moved to a new employer because my EB2 is all been approved at 140 previous. And new employer, it's been 2 months old. I haven't filed the AC21 with them. So now I understand 485J is tied to my EB3 with previous employer.
Right.
Is it safe I can go back just because my EB2 is current? I have good relation with my previous employer.
You can.
And, I go and
you can, but we have a frequently asked question Actually, we have several frequently asked questions on this. When you try to rejoin the old employer, questions like, why did you leave? Do you still have the intention to join them permanently? Do they have the intention to offer you the job? Did the job ever discontinue at any time? So all of those questions need to be discussed with your lawyers. But as long as those questions are resolved, absolutely you can go back to the old employer.
But only once I get green card, only I can go back, right?
No, you can go back now using your EAD or another H-1B. No, you don't have to wait till you get your green card.
Okay, because I just want to go to back to employer if I get green card. So
well, that I think
that
you should discuss with your lawyers. Theoretically, that's possible, but practically it looks quite fishy, where you've left the old employer and you are just filing a 485 under EB2 because it's advantageous. So the government could look upon it with suspicious eyes, but theoretically that's perfectly fine. If you have a good explanation, you can do it.
Okay. Is it safe to do my 485J now with the new employer?
Yes.
Even though I decided to go back?
Why would you want to do a supplement J if you're going to go back? I don't see any point in it.
Yeah, just in case, like for this 2 months.
No, I don't think you should.
Okay.
Okay.
Okay. Okay.
All right.
Thank you.
Good luck, sir.
Thank you.
All right. Bye-bye. We have one more. Last question is from New Jersey, 609. Go ahead, please. 609. Go ahead. Let's try again. 609. Can you hear me? 609.
Yeah, can you hear?
Yes,
can you hear me?
yes. Sorry, I think I messed something up.
Okay.
We are good. Yeah, go ahead.
Okay, thank you. This is a question which I posted it. I'm sorry I joined a little bit late, so I missed what you said for the first question. So
I'm not going to
repeat.
I'm not going to repeat because I've already gone through a lengthy discussion. Wait till the recording comes out. All right?
Okay.
Good luck.
Okay, sure.
Yeah, I can't go back and repeat. That was a very lengthy explanation. Next question is AJ Mahesh. Again, interfiling. EB3 to EB2 was downgraded. I think what we mean is EB2 to EB3 was downgraded. It's a little error here. As per the amendment, can I now interfile? So my EB3 was downgraded to EB2 in October. Okay, got that. And the attorney marked the amendment box. Okay. I received the EAD combo card, changed the employer, transferred using AC21. Now my priority date is June 2012. EB3 is retrogressed. If I interfile EB2, well, first of all, you cannot interfile because you are not with that employer who holds your I-140, EB2 I-140. Second, you are right, at least the classical understanding, and I don't have any other explanation from the government to the contrary. The classical understanding is if you downgrade and you check mark amendment, then your EB2 is converted to EB3. If you want to go back to EB2, you have to file a new I-140. But what you should do, and what all of us do, when we file for the downgrade, we don't file it as an amendment, we file it as a new I-140. So there are two reasons I think you have a problem. One is a clear-cut case that you're not with that employer. And the second is, I doubt that an amended case can be just used without filing a new I-140. I don't think so. If you interfile, will there be an impact on your EB3? It could be, because my concern is you have moved using your portability, AC21 portability, and you are relying upon that 485 connected to your EB3. Government has only said this: if you ask for an interfiling to EB2 back again, your 180 days begins from the date of the request for interfiling, which means, from what I understand, your old AC21 rights are destroyed, although I doubt very much that government would be able to win such a case in court. However, that's a gray area, and I would be very uncomfortable advising people to go that route. What is the best way to have both EB2 and EB3? Have your new employer start a new case, start from perm upwards. Star 5, if you have a follow-up question on this. Star 5. Okay. Another interfiling question. Maintaining H1B status once I-485 EAD is received after downgrading from EB2 to EB3. I am on H1B past 16 years. I received my I-485 EAD after downgrading. Can I work full-time for my own company now in the same field, or do I still have to have an employer? So the question is a little bit different. It's actually not so much about interfiling as it is about using portability to go to your own company. So my I-140 is approved. 485 has been pending 180 days. Can I now port over to my own company? And the answer, theoretically at least, is yes. Government clearly allows that. But there are a lot of wrinkles. Make sure you understand all the nuances. Make sure you talk with a lawyer. And make sure that they cover all the angles, including employer-employee relationship, genuine job offer, etc., etc. And then you can do it. I don't see any reason why you cannot. Star 5, if you have a follow-up question. Star 5. Okay, let's go on to the next frequently asked question. Again, interfiling, returning to old employer. A lot of interfiling questions today. My priority date is 2014 for EB2. With an approved I-140 with Company A, I joined Company B 3 years ago and I've not started the perm process. My priority date might get current in the next 5-6 months. I'm thinking of going back to Company A. They are okay with it. What issues will I face with USCIS after they file for I-485? So the risks, I have talked about it several times. Go to our frequently asked questions, read through them. I can't keep repeating the same issues that are already in the frequently asked questions. The bottom line is, why did you leave them if you wanted to stay with them indefinitely or quote forever, permanently? Okay, why did you leave them? 2, why did they let you go if they needed you permanently? 3, while you were gone, did your job discontinue? So if you left them, did they just scrap your job or somebody else was doing that job? So these are some of the questions that you have to deal with and make sure that you have comfortable answers for them. Don't make things up. Truthfully comfortable answers. And if you do, then going back is an option. Otherwise, it is not. Star 5. If you have a follow-up question, press star 5. Okay, this is from our neighborhood, Washington, D.C. Go ahead, Washington, D.C.
Yeah, I have a question. So, regarding the interfile. So, if somebody changes the employer, after downgrading from EB2 to EB3, and after 180 days using AC21, and then the new employer, is willing to file for the EB2 because since the date is current. You said that we have to start filing the new I-140 and new PERM.
Yes.
But can we not just use the old PERM?
No.
Here, because PERM takes one year or
no. PERM is affixed to a particular employer and a particular job.
Got it.
Okay.
Okay.
Good luck.
Thank you.
You're welcome. Let's see. Do we have any other frequently asked questions? No, it doesn't look like it. All right. Let's go to answering the regular questions. After the frequently asked questions, FAQ. Here's one. H4 and adjustment of status after divorce. First of all, thank you very much. You're very welcome, sir. So, getting divorced while on H4 dependent visa will make me go out of status? Yes. Yes, it will. Currently, I'm waiting for EAD on EB3. Do you advise me to apply for interlink EB2 as well so I can get the EAD sooner than EB3? I don't think it quite works like that. So if you interfile back to EB2, although they have given us a new address these days, it might make your EAD come sooner, but if they had not given you that specific address, a new address that the government created just for these kinds of cases, then it might hurry things up for you a little bit. It's hard for us to predict because this new address is just a couple of weeks old. So there's not a whole lot of data to rely upon. So the answer is, does interfiling back to EB2 make my EAD come faster? The answer is maybe. Under the older times, it would not make a difference. Under the new times, it might. Husband is on EAD, EB2, and in November 2021, he got into criminal charges, assault and battery, etc. The case was dropped. What would be the impact? Well, the case is not necessarily rejected, because if the case was not prosecuted to either some kind of a plea deal, or it was not prosecuted to some kind of a diversion program, which is basically like a conviction. So if he was not convicted, there should be no consequences, but you have to talk to your own lawyers, because this is a very tricky area of the law, including considerations like, did you file anything with the court during the criminal proceedings that admits the elements of the crime? So even if you don't get convicted, you are still under immigration law either excludable or deportable. So there are all sorts of considerations. But I would say normally when a case gets dismissed without a conviction or any adverse findings on the record, you should be okay. I've been the owner of a C Corp for over a decade. I was on H1B, currently on H4. I'm expecting EAD soon. I've not taken any pay, salary, or profits. Does that impact my EAD or green card? It could, because if you have a company for which you work actively, that's probably illegal as an H4 dependent, unless you have an EAD. *5, if you have a follow-up question on this, press *5. Okay. Next question. F1 visa internship rules and chances of getting an H1 visa. Aleta says, I'm on an F1 visa. I entered the US in 2020, took up an internship approximately a year later. A year later. She was not authorized to do so. My university's DSO advised me to leave the country, get my visa stamped again, and re-enter. Does it reduce my chances of getting an H1B visa? Not at all. Not even a little bit. What is the best way to deal with a scenario like mine? Well, yeah, the OPT could be problematic because you need to maintain status, I believe, for 2 full semesters. Do 3 paychecks really come into attention? And the answer is yes, because breaking the law is breaking the law, even if you did that inadvertently, not knowingly. But your DSO is the real authority in such a case. Okay. So I would go with cooperating with them and finding out what they say. *5, if you have a follow-up question, press *5. Okay. So this is a fact. Can a senator help my daughter get a green card? This is question number 10. They received their green card under downgrade. Could not file for daughter. She was close to aging out. Then you filed under the CSPA rule. She's also received her EAD. Since the EB3 dates retrogressed. Okay, so once again, let's understand the circumstances a little better. Could not file my daughter's AOS as my daughter was close to aging out and her F1 was still pending. Once I received my green card, I was able to file for my daughter's under the CSPA rule. Not sure how that covered. I guess your I-140 must have been pending for quite a while. Her I-485 petition was accepted. So now the question is, can approaching a senator or congressman help in getting the green card? Or is it out of their jurisdiction since the priority date is still not current? So if the priority date is not current, the congressman cannot help you. Are they sure to get to approve the case? No. Just because they issued the EAD does not necessarily mean they are going to approve the case. Your daughter's application can be, Manishi, rejected if she is not truly covered by the CSPA, the Child Status Protection Act. She should maintain her F1 in my opinion. You should not go to EAD, etc. *5. If you have a follow-up question, press *5. Okay. This is question number 11. H1B Dropbox stamping in India, Payslips documents DS-160. I'm planning to go for Dropbox stamping and planning to physically stay from March 1st to March 30th. Legally, is it required for an employer to run the Payslips irrespective of the scenario? If you're on vacation, you should put it down in writing that you want personal time off and you accept the company policy of not getting paid for personal time off. That should be okay. As per my understanding, whichever employer I mentioned in DS-160 form, that'll be considered my employer. Not sure I can answer that question accurately, but normally whatever you put down in DS-160, that's what you're claiming is the truth on the date you filed the DS-160. What are the minimum required documents? No clue. They give you a laundry list of what you need to submit. Just follow that. If I work for two different clients for same employer, is it okay to do that during stamping? No idea. There are too many variables in what you've asked me. Talk to your lawyers because I don't know what you mean by is it okay to do that during stamping. Are you saying you'll be working from India? In that case, you should be paid. So I don't really know what that question means. You have only one stamping, which is L1B. No other stamping. Am I eligible for Dropbox for H1B stamping? So the Dropbox, I think, requires that you must be in the same visa category. I could be wrong, but I remember this being as one of the conditions. However, the interview waiver, which is almost like a Dropbox, pretty much like a Dropbox, which was a relatively new procedure. That said, if you have ever had a visa stamp of any kind, never had any visa denials, applying from your home country, we might waive the interview. You may not have to come in, which is like a Dropbox. So for Dropbox itself, I think you're not in the same category in which your visa was. It's not like a visa renewal. Again, I could be wrong about this. I'm speaking from memory. I don't exactly remember what the rules are, but they're fairly straightforward to read through. *5 if you have a follow-up question. So the point is, even if you don't qualify for Dropbox, you qualify for interview waiver. Okay. Does it matter? This is question number 12. I thought there were only 12 questions. Does it matter if I use family-based EAD AP while employment-based I-485 is pending? I don't see any reason why not. They're going to combine the 485 at some point of time anyway. It should not affect your employment-based 485. Any follow-up questions so far? *5. Okay. Last question. Change of status from F1 to H1B. I'm a master's student on F1. Last semester is September-December 2022. Taking only one course to finish my degree. Companies registering for H1B lottery. If I get picked up and change my status to H1B on October 1st, before my classes have completed, how does that impact me? I don't see why it should impact you. As long as you have a bachelor's degree that qualifies you for the job that you're going to do under an H1B. Because remember, you can go to school on H1B if that's your concern. You're allowed to go to school while you have an H1B. Can I keep attending classes from October to December? Yes, you can. On F1, I need to be in person. Can I attend classes remotely? I believe so. I certainly believe so. Talk to your DSO. I think you can. Can I commute from Boston to my university to attend classes? Again, I don't see that as a problem at all. I've never applied for OPT at the master's level. So can I get OPT at the master's level for another degree in the future? You probably could, because if you've not used it, you can use it for another degree. How likely is USCIS council office to frown upon this in the future? Switching to H1B before completing my master's degree. It's your legal right. I don't see any problem with it. press *5 if you have a follow-up question. Okay, folks, I think we are done with the posted questions. In fact, we are. So any question at all, press *5. Anyone has any question, press *5. Okay, just 2, 3. Oh, 3 I can do in my sleep. No problem at all. So let's go in the order that you logged in. So this is North Carolina. North Carolina, go ahead, please. What is your question?
Hi. My question to you is, I'm on H1B with company A right now, and I got an offer with company A, and my H1 transfer is approved. I'm expecting to start with them next week.
Okay.
So I got an offer from employer C 2 days ago, and I'm interested to work with them.
Okay.
Will there be any problem if company C initiate my H1 transfer at this point?
Okay. Are you still with company A, sir?
Yes.
Okay. Absolutely no problem. At least from immigration perspective. From contract perspective, if you have signed something, you should look into that, but no problem from immigration perspective. Okay?
All right. Thank you.
You're welcome. Okay, somebody else just raised their hand. Let's go to them because they called in first. This is back to DC. So yeah, Washington DC, go ahead, please.
Yeah. So my question is, I changed, change the if you change the employer or on AC21, do we need to file the supplement J right away, or should we wait? Like, I'm just contemplating, why volunteer and file it.
Yeah, I usually file it as soon as I can, but law doesn't require you to file an AC21 supplement J until the government asks for it. So if you wanted to wait, you could discuss with your lawyers. I just think the better practice is to file as soon as you can. However, if you delay it, it should not cause you any damage. Okay?
Okay, so it won't be like, when if they call it for an interview, they might ask, hey, why you did not file?
We have actually, no, you'll need it because it's a job offer. You will need it. We have sent in people with supplement J in hand. So you can even file it by hand at the interview. That's not a problem. Okay.
Okay. And then one more question. So if we change the address, like if we move, do we at that time also do we need to file supplement J?
You do not. You need to file AR11.
Okay.
All right. Good luck.
Thanks.
Okay, let's go to Florida. Let's go to Florida. Florida, go ahead, please. Florida.
Call.
Yeah.
I have a question on I-1. Hi. So I have a question on I-140. So my I-140 approved with a title A, and I got promotion. I got title B, and my extension is coming up next month. So with this title B, my job responsibility is like it changed like 10% only. So my extension is coming up. Do we need to file a new firm because of this title change?
That's a tough question to answer. I would say, generically speaking, if the differentiation in the job or the difference is 10%, it doesn't look like a substantial change. So at least theoretically, I don't see any issue, and I think the same firm should be good. Okay.
Okay, I'm trying to, in the same extension process, I'm trying to file my wife's H4 EAD. Let's say they come up and we need to file firm. So how that H4 EAD do we need to wait to approve the new I-140 then go for H4 EAD?
No, that H4 EAD can be extended even while the old I-140 is in play. So I don't think you have to wait for the... remember, there's no amendment of the I-140. You'll have to start from the perm again.
Oh, okay, gotcha.
Okay.
Sure. Yeah, thank you, sir.
Good luck. All right, so we are done with this one. The last question of the day is from Seattle, Washington. Washington, go ahead, please.
Hello, sir.
Hello.
So my question is, my husband got his EAD under EB3. So and he has another filing for EB2, which is in progress.
Okay.
So it's not been 180 days for EB2.
Okay.
He's just 3 weeks away from the priority date.
Okay.
So my question is, if I use EAD under EB3, will it have any impact on his EB2 processing?
It should not. Okay.
And for him, is it mandatory that he has to wait for another 180 days for his EB2 in order to switch employers?
Yes, because if you do interfiling, I think that's what you asked me, right? You want to go from EB3 to...
No, his is not interfiling.
Achha.
This is a new filing for EB2.
Oh, okay.
So his
Yeah.
EB3 is... Yeah,
Okay.
EB3 was past 180 and he got EAD, so I also got EAD.
Okay.
Now, his EB2 is just 60 plus or 65 days.
But
And,
you want
priority
to
days is
you
like-
want to
yeah.
file a new 485 or interfile?
No, it's already been filed. His EB2 485
So
is already filed.
so he has
and
two
it's been-
he has two 485s, one under EB3, one under
Yes.
EB2. Okay.
Yes.
So here is the situation. Technically, if he moves right now, he'll be moving his EB3 job over. Okay. Once the 485 under EB2 has been pending 180 days and the I-140 is already approved under EB2, he can then port that job over. Now remember, technically, you don't have to be in that job for 180 days. Your 485 just should remain pending for 180 days, which means it was not called in question by the government. However, I think it is a little risky to change jobs before 180 days are over. I prefer to avoid that situation. Okay.
I-140 was approved simultaneously and it's been more than 180 days for both EB3 and EB2.
When was this 485 filed?
December.
Yeah. So he can move in June because the 485 was not pending 180 days.
Okay, so 485 has to be pending
Right.
or at
So,
least 180
right.
in EB2 for him.
Right. The law says
Okay.
I-140 is approved and 485 has been pending 180 days. So let's say that your husband had filed his I-140 and 485 together, and the I-140 was approved after 150 days. Now he only needs to wait 30 days because after 30 days, 485 would have been pending 180 days. But when he staggered, he got the I-140 approval, then he filed his 485 alone. 485 is not yet pending 180 days. It becomes pending 180 days in June.
Okay, so I can use the EB3 EAD and it will not have any impact on his...
I don't see why. No impact. Okay.
Okay, sounds good.
Good
Thank
luck.
you so much.
You're welcome. Bye-bye. So folks, that's the end of our calls today. Thank you all. It's great to talk with all of you and I'll see you again in 2 weeks. Bye-bye.